Hello, can you hear me? Hi, is someone there from NLU Ranchi?
Yes, we can perfectly hear you.
Okay. So should I begin with the lecture?
Ma'am, I'll just introduce you.
Yeah.
So, good morning, everyone. This is Priya Kumari, student member from Center for Study and Research in Intellectual Property Rights. CSR IPR is one of the foremost centers of excellence in the realm of intellectual property law in northern India. The prior aim of the center is to contribute legal scholarship and research in the field of IP litigation and disputes. More in meticulous, the center wishes to gain a better insight and glimpse into new and evolving areas of intellectual property law, such as the protection of software, semiconductor products, and biotechnological inventions, standardization and technology transfers, and the general problems of patents, trademarks, designs, and copyright. The center has recently got the MHRD DPIIT IPR chair. The center is involved in various extensive research projects had on intellectual property rights and technology. Today we have gathered here for an online lecture on constitutional aspects of IPR in India, and as the and we have with us as the guest speaker Miss Ankita Bali. Ma'am is an accomplished professional with extensive experience in the field of international policy and affairs. She completed her post graduation from National Law Institute, University Bhopal, and since then worked in the Ministry of Commerce and Industries, Government of India. Her expertise lies in the areas of constitution and administrative law, along with international trade and trade policies. Throughout her career, Ma'am has participated in numerous national and international conferences where she has represented the country and shared her knowledge and expertise with the international diaspora. She has also been a keynote speaker at various international seminars where she has delivered insightful talks on a wide range of topics related to constitution, administrative law, international trade, and policy. Over to you, ma'am.
Thank you, Priya, for a beautiful introduction. Thank you for giving me the opportunity for organizing this lecture. It's a medium of interaction with the young minds, and hopefully, after the lecture, there's exchange of knowledge, not just from my side, but I get to learn something from your end as well. So, thank you, Ineni Raji, for this opportunity. Now, I shall begin with the lecture that has been assigned to me. Constitutional aspects of intellectual property rights in India. Many of you must be thinking that we are here to talk about intellectual property rights and how is it related to constitution, and why these two things are interconnected. Constitution does not expressly mention about the intellectual property rights, but I will relate it with the constitutional provisions and tell you as to how these two things are related from my point of view, and then I would like to hear from you guys as well, because all the laws that are drafted in India, they derive their power from the constitution, and nothing is over or above the constitution. So the constitution is supreme. And all the laws that are drafted, as I told you, they derive their power from the constitution. So how is intellectual property rights related to the constitution? Let me just give you a brief of the intellectual property rights. I know many of you must be aware of it, but then I will relate it with the constitution. So, intellectual property rights, what is it? It is basically creation of human minds and human intellect. And you basically something that is a creation of your mind, you want to protect it. And the intellectual property rights or the IPR and different acts under the IPR that give you the power to protect your own creation. So basically, nobody can exploit that thing and use it something that you have created without your empowering the other person to use it, they will not be able to use it until and unless you give them those rights to use it. So that is basically intellectual property rights. And in the present scenario, if you see, it is a medium for not just for creation of things, but it is also a medium where economies are growing because of the things that we are creating. Our mind is creating because of it. You are getting a lot of money. There is exchange of technologies happening through intellectual property rights, because you are creating your own copyright, your own trademark, your own patents, and then you're selling it to the other people also and getting money in exchange. So it is a way in the present era that the economies are also growing because of the intellectual property rights. Now, when I talk about the constitutional aspect to it, do we see any provision in the constitution which expressly talks about intellectual property right? The answer to the question is no. There is no provision which expressly talks about it. How these acts have been created when it comes to intellectual property right? Now, just let me go into the part 3 of the Indian Constitution, which talks about the fundamental rights. Now, if you see under the fundamental rights, there was earlier right to property also, which was a fundamental right. After the 44th Amendment Act, that was removed, and it was a constitutional right and no more a fundamental right. But when we talk about the concept of property, are we just talking about land and not the other kinds of property? So the Supreme Court in a judgment has stated, I will tell you the name of the judgment as well. Is the Supreme Court has very clearly stated that when it comes to property, it is not just the land that we own. It is about anything that we have created, like any trademark you have created, that will also be covered under the concept of property. Any copyright you have, that will also be covered under the concept of the property. Geographical indications would also be covered under the concept of property. And before the 44th Amendment Act also, when it comes to fundamental right, the concept was that they have to be interpreted in a very wide manner. They should not be interpreted in a narrow manner, in a restrictive manner. For example, if you talk about right to life has been interpreted in such a beautiful way, and the interpretation includes a lot of things, like right to sleep is also a part of right to life, right to privacy is also a part of right to life. So a lot of things are there which is covered under the purview of right to life. Now, if we were giving a narrow interpretation to it, or as we say in the legal terminology, a literal interpretation to it, then the things would not have been the same. These things would not have been covered under the concept of right to life. Just because we know the intent of the lawmakers, the intent of the lawmakers was that the fundamental rights should be interpreted in a very broad manner so that people enjoy the rights that are there, not in a restrictive way. And India being a democratic country, India being a country for the people, by the people, of the people, so therefore these fundamental rights were also considered to be interpreted in a broad manner. Maneka Gandhi is a wide example to it, as to how the Supreme Court stated that the fundamental rights should be interpreted in a broad manner. I will just read out a few lines of the Maneka Gandhi judgment and then relate those things with the intellectual property rights. So Maneka Gandhi judgment basically stated that these fundamental rights represent the basic values cherished by the people of this country since the Vedic times. So it is not, the fundamental rights are not just limited to the present era. They have been there before the constitution came into being. They have been in existence since the Vedic times, and they are calculated to protect the dignity of the individual and create conditions in which every human being can develop his personality to the fullest extent. So that's the beauty of the judgment, that they have interpreted it in such a beautiful manner, that they say that these rights should be interpreted in such a manner that they give the idea of development in a fullest form, not in a narrow form. Justice Bhagwati has stated that the correct way of interpreting the provisions of Part 3 is that attempt of the court should be to expand the reach and ambit of fundamental rights rather than to give them a restrictive meaning, and the content should not be restrictive in nature. So that's the beauty of our fundamental rights. So I was saying that earlier under Article 19(1)(f), right to property was a part of fundamental right, though it was removed later on and made a part of Article 300A. it was made a constitutional right and not a fundamental right. So, but the idea was that earlier it was a part of fundamental rights in the Supreme Court in the case of KT Plantation Private Limited versus State of Karnataka. This is a 2011 judgment, and also I will refer a judgment of 1957 also. Since that time, we are saying that property does not only mean a property in a tangible form. Anything that you've created, anything that is your creation of a mind will also be covered under the concept of property. So in a way, if you see Article 300A also, when you're talking about the right of having a property, it is also talking about, and the protection of property, it is also talking about protection of intellectual property rights. Anything that is covered under the concept of intellectual property rights would also be covered under the concept of Article 300A. Another example I will give you of the Constitution where we are in a way talking about the concept of IPR is entry 49 of list 1 of 7th schedule. So it recognizes, it mentions patents, inventions, designs, copyrights, trademarks, and mercantile marks. So basically, at entry 49 of list 1 of 7th schedule is also no mentioning about it, though not expressly mentioned, but again, right to life में भी बहुत सारी चीजें ऐसी include हुई है which have not been expressly mentioned under the Constitution, but because of the beautiful interpretation done by the courts today, we have plethora of rights that come from right to life also. So again, in a way, we have interpreted the Constitution in such a manner that a lot of things are covered under the concept of right to property. Now, before I begin with the other provisions, I will just take you to what kind of intellectual property rights are there and how the constitutional provisions are related to it. I gave you two examples, Article 300A and entry 49 list 1 of the 7th schedule, which basically talks about earlier, before the 44th Amendment Act, Article 19(1)(f) was also there, which was a fundamental right, which talks about the concept of right to property. Now, what's the classification of intellectual property rights? First thing is copyright. For you guys, it's not a new concept. It is something which I should not tell you, but I'll just give you a brief of it. So copyright is basically anything that the creator that you create in the literary field, in the dramatic field, in the artistic work, anything. And it's a kind of a negative right, which basically means that the right of copyright owner to prevent all others from copying the concept. So what's the difference between a negative right and a positive right? Anything that says that you cannot do so, you will not, any negative kind of an attributes, not, never, all these things, they basically tell you that it's a negative kind of a right. And when we say that you can do all these things, these are positive kind of rights. So copyright says that you cannot copy my work, you cannot copy my artwork, you cannot copy my anything that has been created in the literary field. So that's basically a negative term, and that's the concept of copyright. Now next is patent. Patent basically means the monopoly that is granted to a person by a patent office to exploit its invention for a limited period. So here the limited period in our country is 20 years. So anything that is patentable, by you have got the patent and you have the rights, you can enjoy it for a period of 20 years. And during those 20 years also, if you want the other person to use it, you can do so by exchange of money and the contract that you guys have. So that is patent for you. Another thing is trademarks. You get a symbol, you get a different kind of a recognition that this product will have this kind of a symbol, and that's how I recognize that this is my product. So that's trademark. So another is geographic indication. Basically means that you are developing a particular thing because you live in a particular geographical area and you have a benefit of that particular thing. So you get those kinds of a right that I will only be in a position to use those things and produce things out of it, and no other person would be entitled to do so. However, if you, again, for exchange of money, you can do so. Another thing is industrial designs. So designs again gives you shape, configuration, all those things. So you can get your industrial designs also registered, and again, no other person would be able to use it. Then you have trade secrets. For example, trade secrets is basically where you sign a contract with the other person that we are not going to disclose these things. Lot of times we ask about I work in Ministry of Commerce and Industry, so a lot of times we ask few details when it comes to the investors who are investing in India. So when we are asking them, they say that we have a trade secret agreement with the foreign investor and we are not supposed to disclose those particular kind of things. So that is an agreement or a contract that you have with your partner, that I'm not going to disclose this particular thing. It could be how you have created a particular thing, what is the kind of a technology that you use for that particular thing, and you do not want the world to know it, because if everybody knows this, obviously they can start using that particular thing and they can also start producing that particular thing. So you have a trade secret and you do not want the world to know it and basically make money out of it. So that's also allowed. Then these semiconductors, integrated circuits or layout designs, again these are a very small circuit or designs that a particular individual has invented, and that particular individual only knows how these things can be used. Again, that person would not want the world to know that how these things are created, because again the problem would be that they would also start producing. That person has a monopoly and that person wants to keep that monopoly, and it's absolutely allowed under the trademark laws or the patent IPR laws that we have. So basically all these things are there, which talks about a brief introduction of the intellectual property rights. Now another thing, as I was talking about, that when we are asking about our foreign investors to reveal a certain things, and they have a trade secret agreements with their foreign investors and they're not supposed to disclose it. Now under article 253, it empowers the parliament to make laws for whole or any part of the India for implementing treaties and international agreements. So there are treaties, there are international agreements also between two nations, where you might have these kind of trade secret agreements that you're not going to disclose. Again, in a way, we are talking about intellectual property rights under article 253 also, where you are saying that the two governments may enter into any kind of a contract. They might have an international treaty agreement where they say this thing, that we are not going to disclose this particular thing because we have a trade secret agreement. So in a way, again, you are talking about the concept of intellectual property rights. So in the entire constitution, if you see, nowhere intellectual property rights has been expressly mentioned, but you will get bits and pieces here and there in the constitutional provisions, and the way you interpret it and the way the courts have interpreted it, that you get to know that this particular, how this is a part of the intellectual property right. So again, moving further to Article 372. Article 372 states that notwithstanding the repeal of certain conditions laid down in the provisions, all the laws in force in the territory of India immediately before this constitution or the enactment, before this enactment, will prevail. So basically Article 372 says कि हमारा कॉन्स्टिट्यूशन बनने से पहले भी जो लॉज थे वो in existence रहेंगे, वो until and unless you repeal those laws. Like the Indian Penal Code, the CRPC has been recently repealed by the Parliament. But if you see, they were in existence. These are the acts that were in existence even before the Constitution came into being. So anything that was talking about the protection of your property, like the Patent Act, it was there of the year 1911, and then it was repealed and reintroduced, and the current is the Patent Act of 1970. So again, all these things are there, which basically talks about that the laws that were already there before the constitution came into being, until they has been expressly repealed, they will still reveal it to existence. So again, 372 is talking, that is why Patent Act was in existence. And how patent, now it has been repealed, and now you have the current Patent Act of the year 1970. So there are few, if you see bits and pieces, again, as I was telling you, that they talk about the concept of intellectual property rights. So how many provisions have we covered under the constitution, which in a way talks about the concept of intellectual property rights? Can someone repeat for me? Any student who would like to answer that question for me? Please try to be interactive, then only I can know, because I cannot see any one of you, and then only I can get to know that whether you're actually understanding whatever I'm saying, or is it just bouncing. Anybody who would like to answer? How many provisions have I mentioned in this lecture of the Constitution which talks about the concept of intellectual property right, though not expressly mentioning it, but in a way they are related to the concept of intellectual property rights? If you do not want to answer it, you can also write in the chat box. I can see that there is a chat box where the students can answer. No responses as of now. So I will give you again a brief of it if it's not understood. Article 19(1)(f), which was basically talking about the concept of right to property, which was removed by the 44th Amendment Act. Property, the Supreme Court, in the case of KT Plantation Private Limited versus State of Karnataka, has stated that it does not only mean a tangible kind of a property, something that can be seen. It could be the creation of mind also, that is covered under the concept of property. Then, after the removal of Article 19(1)(f), we had Article 300A, which was inserted, and it is a constitutional right that talks about the concept of right to property. And as I stated you, the right to property will also cover all those things that you have created under the intellectual property rights, and you have the right of stopping others from using your creation. So that would be covered under the concept of right to property. Then entry 49 of list 1 of 7th schedule of the Indian Constitution, it mentions patents, inventions, designs, copyright, trademark, merchandise marks. So in a way, talking about the concept of intellectual property rights. So, and Article 253, which says that the Indian government has to respect the international treaties, negotiations that we have signed with the world. The best example of it would be the World Intellectual Property Organization. Then you have trade related aspects of intellectual property rights. So all these powers that have been exercised, or that these treaties which are in existence, are because Article 253 gives you that right. So for that is also there for the protection of the intellectual property rights. Another thing is Article 372. Article 372 says that any laws that have been created before the Constitution came into existence, they will remain into existence until and unless they have been expressly repealed by the constitution or by the parliament. Because as you know, under Article 13 it says that any law which is in contradiction with the fundamental rights of the country, that will be repealed and that will not be in existence. So another example as to how which laws were repealed were the laws that were in contradiction with part 3 of the Indian Constitution. So apart from it, it expressly says that until and unless expressly it has been repealed by the parliament, they will be in existence. Patent Act 1911 is an example to it. However, it was later on repealed, and now we have the Patent Act of the year 1970. Now, when it comes to how fundamental rights are related to the things under the IPR, I will give you examples of it. I told you under Article 21, for example, right to life has been interpreted in such a beautiful and a wide manner that a lot of rights are covered under that concept. Now, supposedly, in the present era, in the COVID times, you have created a certain kind of a drug, okay, say for protection under COVID. Now, that's your creation. That's something that would be covered under the concept of intellectual property rights. So now the world knows that this particular drug is important because this can help us fight COVID in the present scenario. So that becomes a part of Article 21, right to life, because in a way you're protecting the lives of the individual. So again, how these things that are covered under your intellectual property rights would also be covered under Article 21. So because medical, if you have created a certain kind of a drug which can save the life of the people, so you obviously it would be covered under the concept of right to life. Another thing is Article 19(1)(g) gives you the power to practice any kind of a profession, trade, or a business. Now you have created something, you're making money out of it, it's a business for you, it's a trade for you. Again, you are covered under the concept of Article 19(1)(g). It could be your patents, it could be anything else. Now earlier, when it was a part of the fundamental rights and property was a part, right to property was a part under the fundamental rights, if that right was violated, you could go directly to the Supreme Court under Article 32 and under Article 226, you could go to the High Court. Now, just diverting from the topic and telling you what is the difference between Article 32 and 226 is, under Article 32, only and only if your fundamental rights have been violated by the state under Part 3, then only you can go to the Supreme Court, which is a restrictive kind of a right. Under Article 226, it could, if even if your fundamental right or any other constitutional right has been violated, you can go to the High Court under Article 226. So that's a difference. That's a wider concept when it comes to Article 226 under the High Court. And then you have 5 kinds of writs. You're all law students. You must be aware of these kinds of writs. So now, since it's not a part of the fundamental right under Article 19(1)(f), we cannot use Article 32. Although if 300A is violated, you can go under Article 226 to the High Court. Now, copyrights, again, you have those particular thing, you have created something, you can protect. For example, you've created a book. Now you want a copyright for it. You can do so. You can protect. You do not want the other people to use that kind of a thing. Whatever you have written and quoted in their book without taking your permission, you can do so. State of Maharashtra versus Prabhakar is an example to this particular thing as to how things can be included and how you can protect your copyright, which is again a part of, see, writing a book is expressing yourself, whatever you have stated. That's a part of Article 19(1)(a) of the Indian Constitution. So freedom of speech and expression, though not an absolute right, there are restrictions to it, but again, that gives you, that's a fundamental right of expression. So writing a book and getting that copyright act of it, copyright rights for it is an example, and it is covered under the concept of Article 19(1)(a) and also under Article 21, which talks about liberty as well. Geographical indications, again under Article 19(1)(g), it would be covered. Goods Registration and Protection Act 1999 was developed because of this concept. You live in a particular territory, you have a characteristic of that particular territory where you come from, then you can use those indications and use that particular thing and get it protected. And it would be covered under Article 19(1)(g) also, because of the profession that you want to carry, trade profession, as I told you, that you have the right to do so. Then you have traditional knowledge and the Constitution. Scheduled tribes के लिए कुछ राइट्स है अंडर द कॉन्स्टिट्यूशन. बायोडाइवर्सिटी एक्ट आपका इसकी वजह से क्रिएट हुआ था. अगेन दिस इज अ काइंड ऑफ अ प्रोटेक्शन दैट गिव्स यू दैट पर्टिकुलर थिंग बिकॉज यू कमिंग फ्रॉम अ पर्टिकुलर एरिया एंड you have the right. The constitution gives certain kind of protection to you. That would also be covered under the concept of intellectual property rights. So again, as I told you, intellectual property rights has not been expressly mentioned anywhere in the constitution. There is no mention of the term patent and trademarks you get under entry list of the Schedule 7, but otherwise of the geographical indications and all these things, they have not been expressly mentioned. But because of the beauty of the interpretation and the plethora of judgments that have come from the side of the Supreme Court, they are covered under Article 19(1)(g), under Article 21, under Article 19(1)(g), though is not a part of the fundamental rights, but that would be covered under Article 300A, 19(1)(a), 19 and the freedom to carry on your profession, trade, all those things are covered under that particular thing. Article 253 of the Constitution is also there. Entry 49, list 1 of the 7th schedule is also there. So all these things are there that are there in the Constitution, which though they do not expressly talk about the concept of intellectual property rights, but in a way they are there. So this entire lecture, the idea was to give you as to how these things, how everything, every act that has been created in this particular country is related to the Constitution, and nowhere we can say that just because it has not been expressly mentioned, it is not a part of the Constitution. Because anything cannot be above the Constitution, it has to be under the Constitution. That is why you use the terms like, for example, I'll tell you how Constitution is considered as supreme, although it is supreme and everything. But if you see, again, in all my lectures, I mention this thing to the students because it is very important for us as a law student to know that why the term articles are used in the Constitution. When you read a particular act, term sections are used under the constitution. We as policymakers refer it as paras. Then you have rules also. So all these terms are used. Why? Because see, anything which is supreme in nature, anything that is nothing is above that particular thing, the term article would be used. Like the constitution uses the term articles. Then you have acts that are formulated under the constitution, they use the term sections. Then you have policies that are formulated because the parent act gives you the power to frame certain kind of policy or frame certain kind of rules. The term paras and rules are used. So that's the hierarchy that we follow when it comes to showing the superiority of the laws and which laws are inferior as compared to the other laws. So if you read the entire constitution, again the term article is used, nowhere section is used. If you read your patent act, you read your any other act in the country for that matter, sections would be used. Any other rules that are formulated by the government or any other policy, rules and paras, terms like this would be used. So that's a difference between the three kinds of laws that are in existence in our country. All of them have a legal value, all of them can be protected in the court of law, but again, nothing can be against the constitution, and if it is against the constitution, it becomes null and void then and there only. So all the intellectual property laws that you have in existence in this country are also covered some way in and are a part of the constitution. So we do not say that thus just because it has not been expressly mentioned in the constitution, intellectual property rights are not a part of the constitution. They are very much a part of the constitution. And expressly, the Supreme Court in this case that I was mentioning, KT Plantation Private Limited versus State of Karnataka, had stated that property does not just mean a tangible kind of property. I will go through the judgment. The expression property in Article 300A is confined not only to the land alone. It includes intangible things like copyrights, other intellectual property rights, and embraces every possible interest recognized by law. So now it can be said that intellectual property rights are included in the term property under Article 300A. So here the Supreme Court has expressly stated that copyrights, trademarks, everything would be covered under the concept of Article 300A of the Constitution, and that's how you get the right under article or under the Indian Constitution, which talks about the concept of intellectual property right. So that's it from my side. Do you have any other questions? Because it was a monologue. There were no questions asked. If I would be happy to answer the questions, please. Vartika, are you from the organizing team or are you a student who has a question?
No, ma'am, I do not have any questions. I am from an organizing team.
Okay,
Does
okay.
questions?
Anybody who has any questions about it?
Yeah. Ma'am, there's one question from Arshia Vadhava. Which judgment is this again? Can you please repeat that?
Okay, okay. I will tell you the name of the judgment. It is KT Plantation Private Limited versus the State of Karnataka. KT Plantation Private Limited versus the State of Karnataka. It is a 2011 judgment. AIR 2011 Supreme Court 3430, which basically says that Article 300A, which talks about property, it will cover the concept of intellectual property rights as well. I think as a student of anybody who's pursuing IPR, they must go through this judgment and see how they have related it to the constitution. Any other questions? So if there are no questions,
And
yeah.
Shefali also.
Sorry?
Shefali, she has also asked one question.
Yeah, please tell me.
Yeah. She was asking about which schedule list, madam.
Okay, you wanted to know the entry list that I was talking about, right? So it's entry 49, list 1 of the 7th schedule.
And there's one question also. Uh, Someone is asking the difference among laws.
Different.
Please repeat.
Okay, the section, article, paras that I was talking about.
Yeah.
Okay, so yeah, so I was saying that what's a difference? For example, when I say constitution is supreme and nothing in India can be above the constitution. So when I say supreme kind of a laws, always the term article would be used. Article 1 of the Indian Constitution says so, Article 2 of the Indian Constitution says so. So, term article would be used. The acts that are passed by the parliament that are basically empowering the parliament by they are empowered by the constitution to frame laws on a particular issues, sections would be used. Now we as a part of the executive, we as in the government of India, as a part of the executive, if they are framing certain kind of policies, they are framing certain kind of rules, because the act that has been passed by the parliament gives you the power to frame certain kind of rules, certain kind of paras, certain kind of policies, that then the term rules, paras, all these things are used. They are basically policy that has not been passed from the side of the parliament. They have been passed from ordinances, for example, they've been passed by the executive. They are here to stay for a shorter period of time. And because the parent act that has been passed from the side of the parliament, that empowers you to frame certain kind of policies under the concept of delegated legislation, then the term rules and paras are used. So most important kind of laws, superior kind of laws, article would be used. Anything that has been passed from the side of the parliament, because the constitution empowers to use to frame those kinds of laws, the term sections will be used. And anything that is passed from the side of the executive, rules, paras, all these kind of terms would be used. So that's a difference that you basically keep to maintain the hierarchy of laws. I hope I've answered the question. Shifali, are you satisfied with the answer?
Shefali, you can write it in the chat box.
Okay, any other questions?
Ma'am, there's one question. Are IPR are human rights?
See, IPR again, human rights and fundamental rights. All your fundamental rights are your human rights, but all your human rights may not be your fundamental rights. So, human rights is a very wider and an international concept. So, Article 253, it says that whenever you've signed a treaty or an agreement with an international organization with the other countries, you're supposed to protect them. So, that's a part under DPSP when it comes to our Indian Constitution. In a way they're related under fundamental rights also, but human rights is a very wider concept. So it is something which is general in nature, which is United Nations and UDHR might talk about it. India is a signatory to it under Article 253. That is why we protect those human rights in our country also. But whether they are the fundamental right, no, all your human rights are not your fundamental rights, but all your fundamental rights are your human rights. That's a concept that we follow. But under Article 253, if there is an international agreement, international treaty, they have to be respected. And under Article 51 also, which is a part of your DPSP. Article 253 is not a part of the DPSP. Article 51 is, but they have a mention in the Constitution. So in a way, we can say that it is a part of your human rights, but not expressly mentioned anywhere. That's an interpretation. That's how you take it. But it's a beautiful question. Whoever answered it.
Does anyone have any other questions? You can write it in the chat box.
Vartika, I think you have my email ID also. If there are any other questions also, I'll be happy to answer it. You can email me the questions that have come from the side of the students. I would answer those questions on the email as well. If in case you think that you have other questions also, and if the students are not willing to ask right now.
Sure, ma'am. So, good afternoon, everyone. As we come close to this insightful and enriching online lecture, on behalf of Nusral and CSR IPR Chair, I extend my heartfelt thanks to our esteemed speaker, Ankita Bali, for gracing us with her expertise and profound insights. I would like to express our gratitude to all the participants who joined us from different corners of the world and for your active participation and engagement. Special note of thanks to our technical team for ensuring a smooth and seamless online experience. So, we have come to an end. Once again, thank you so much, ma'am, for your enlightening presentation, and thank you everyone who contributed to the success of this online lecture. We look forward to future opportunities for learning and collaboration. Wishing you success and wonderful day. Thank you so much, ma'am.
Thank you, Vartika. Thank you to the entire organization for organizing this beautiful lecture. Thank you for giving me the opportunity. Thank you so much.